My dear students and friends from Law Fraternity, a very good evening to everyone, and I welcome you all to our exclusive webinar on AI and digital technology in arbitration. My name is Dr. Vikas Sharma, and I'm delighted to host this session as we explore how technological innovations is reshaping the future of dispute resolution. Our distinguished speaker today is Honorable Ms. Janet Kurose, who is a Vice President in International Center for Dispute Resolution. She specializes in international law. She's an authority on the subject and will be sharing her inputs. Without much time, I will give the floor to Ms. Janet. Ms. Janet, the floor is all yours. We welcome you on board.
Thank you very much, and thank you very much to everyone today that are here today for your attention. I'm very pleased to be able to share some thoughts and ideas with you today. I'm not sure if we are keeping some time at the end for questions or if people are able to put those in the chat and we will address them as they come.
Try to have a questionnaire session at the end of the session, Ms. Janet. So we'll have that at the end of the session.
Okay, perfect.
Yeah.
Just wanted to make sure. Okay, so I'm going to share my screen so you can see a presentation that I prepared just to lead my thought, to be honest. So yeah, it's can you see my PowerPoint?
Yes, we can.
Good. So I'm going to start with a very brief introduction and history about the ICDR, which is the institution that I represent today. The ICDR is the international arm of the American Arbitration Association. And the American Arbitration Association is about to get his 100 years birthday next year. So it's a very long time history institution that has been around just administering cases, mediation and arbitration cases for a long time. And this is, I can't say without any question that the AAA as a domestic American institution is the biggest institution in the world that dedicates itself to arbitration. So as part of this exercise, at some point, the AAA started administering cases that had some international components, international nexus, and that's when they decided to create a specific division and a specific center that will deal with these specific types of cases. And that was in 1996. At that point, they created a specific set of rules that were different from the AAA's domestic rules and basically dedicated to administer cases that had an international component as defined by the UNCITRAL model law. So we adopted that definition, and anything that has this international nexus will be administered by the ICDR. Our primary case management center is located in New York City, but we also have other staff in other offices that administer cases as well. I'm located in Houston, for example. We have people in Chicago, Miami, LA, and we also have an Asia Arbitration Institute located in Singapore. We also have people from different jurisdictions. Our case managers are lawyers that are licensed in different parts of the world. So we have also this very talented team that dedicates their time to administer the cases with this specific nexus or characteristics. An important thing to mention is what makes the ICDR different from other institutions. So you probably are more familiar with other institutions that have, are for tradition more recognized in the international field. But the ICDR has actually been a pioneer in different forms and different provisions in rules that includes modern structures to implement and obviously enhance the arbitration process. We were, for example, the first institution that created the emergency measures of protection. We also have an online platform to file and manage cases, and I will talk about that once we talk a little bit more about technology and AI specifically. And now we are actually pioneering all these tools in the use of AI in our proceedings. We were recently in a panel with a couple of other institutions, and it's very interesting to learn how we've been implementing all these tools already when other institutions are still waiting a little bit more or being more cautious about all of these. And I will let you know why is that in a few minutes. I just a brief comment that whenever we have a case with an international component that will be managed by the ICDR, even when the parties have provided for other AAA sets of rules. The AAA has rules for construction, commercial, consumer employment, and whenever those rules can be applicable for international cases, the ICDR will be managing those because we understand that international cases have different nuances, different things that have to be considered that are perhaps different from domestic cases. So we find that very relevant. Something that it's very interesting for me is that the rules usually does not reflect exactly what is the policy and the philosophy of administration of the different institutions. Um, I used to work in a domestic institution in Mexico before I joined the ICDR. And to be honest, if we go to a very general comparison between different sets of rules, we can see that they are pretty similar, right? They follow the main principles of arbitration, such as flexibility, tribunal decision authority, and so forth and so on. But what it's really interesting for me is to learn about the policy and the philosophy behind the institution to administer the cases. And I think in that sense, the ICDR has a very unique offer to make. And that is that if you go to the rules, you will realize that they are figures or practices from both civil law and common law combined in the rules. And I'm just gonna make two very brief examples. One is production of documents. If you come from a civil law background, you will probably don't even know what that means, right? We don't have discovery in civil law. But it's when you realize how it works and if it's used in the right way, it can actually improve the process. So the ICDR rules has a production of documents provision with certain limitations, so we don't adopt the US style litigation. If you request the production of a document under ICDR rules, you will have to prove that that document is relevant and you have to identify the document that you are requesting. So that in our view prevents the abuse of the figure. On the other hand, we also promote and prefer, or the rules provides that the proceeding prefers to have written testimonies. So we are not and we mentioned that depositions and interrogatories are not preferred and not the best way to present evidence in arbitration. So we promote the use of written statements. I'm sorry. So the tribunal can check on those statements and then decide whether the witness shall be presented in the hearing or not, making again the proceeding more efficient. The And again, those are just a couple of examples on why we have that combination of practices in both civil law and common law. Another interesting thing is that the case managers in the ICDR system are assigned to a case from the beginning to the end. And even when the case administrator is not making decisions during the course of the proceeding, we definitely are seeing and monitoring what is going on in the case. So whenever the parties need any assistance in terms of communicating with the tribunal or, um, you know, putting out any concerns about the proceeding, they have the case administrator available to present that information and have the case administrator as a connection person between the parties and the tribunal without, having that direct communication and sometimes even not a very comfortable issues before the tribunal. So the case manager in the ICDR model plays that role and helps both the parties and the tribunal whenever there's a concern in the track of the proceeding. Another interesting thing is that even obviously as we are part of the AAA, but we have a specific panel of arbitrators. The ICDR roster is comprised of panel members that have expertise in the different subject matters and that he vetted and trained on the ICDR system and policies. We even have a different system of recruitment for ICDR arbitrators and the local arbitrators we have in the different domestic panels. In addition to that, whenever we have specialized arbitrators on different sectors, we label those arbitrators on this specific experience so we can better accomplish our task of creating lists for the specific types of disputes. Now, just a brief comment about the ICDR rules. So our last amendment was in 2021. You can obviously check the set of rules in our website. And a few points of what makes the ICDR rules different from others. It's just the administrative conference call. If you haven't had an arbitration case with the ICDR, I can tell you that we have this conference call with the parties and the administrator at the very early in the proceeding, even just after we received the notice of arbitration, to put together the information we need to constitute the tribunal and to check basically the content of the arbitration agreement. We take very seriously the way we need to constitute the tribunal and the agreements that the parties have in the arbitration agreement for that purpose. And if there's anything that we need to address because the parties didn't agree on that in the arbitration provision, we can definitely discuss those points during this conference call. And most of the times, to be honest, we can actually amend and reach agreements on the constitution of the tribunal, so the parties can feel comfortable with the tribunal that it's going to decide their case. Also, the arbitrator selection method, it's a little bit different from what some other institutions offer. We have a strike and rank system, which is that we put together a list of arbitrators and we circulate that to the parties if the parties cannot agree on an arbitrator. The parties will have the opportunity to strike and rank the arbitrators in order of preference, and we will make a selection according to the parties' options or according to their ranking, instead of doing like a administrative appointment directly from the institution. And the purpose of this is to have the parties participate in the selection of the tribunal as much as possible. The arbitrators are also compensated by hourly rates. That it's also something that we believe helps the parties to keep control of the costs of the arbitrator, and also, be able to manage how they are investing the arbitrator's time. We usually request 10 hours on the very beginning of the case so the arbitrator can cover all these preliminary stage with those 10 hours. And then, depending on the procedural order, the schedule of the case, we will request additional deposits from the parties. And again, the administrator is monitoring all the expenses, all the invoices that the arbitrators submit, so we can keep a good control of what's going on financially in the case. We also have an administrative review council, which is the body that makes different administrative decisions through the course of the arbitration. This council decides challenges on arbitrators, if there's any discussions about place of arbitration, number of arbitrators. The council also decides whether the requirements to file a case have been complied. So this is the council that, again, decides all the administrative issues during the case. And it's particularly important for us because this council is an internal body that it's comprised of people from the same team. So confidentiality will not be an issue. Everything is managed and known by the same group of administrators within the organization. So we are not sharing information of cases with anybody else or any outside body. Another thing, well, I've already talked about depositions and interrogatories that are not appropriate according to the rules. Again, because we are trying to make a very good mix and healthy combination of practices between civil law and common law. And finally, I want to make a comment about the review of the award. Even when we don't have a scrutiny process, we actually review the award. This is reviewed by two people from the team, again, in-house, let's say, people from the organization. That is the only people that have access to these documents and the details of the case. And the purpose of this review is to make sure that this is not going to face any issues in the enforcement stage in case we need to do that. After our review, we make suggestions to the tribunal. The tribunal is free to adopt or deny the suggestions we make, but most likely they will consider it because it's just a review of the form. We understand that nobody knows the merits of the case better than the tribunal. So we just want to make sure that the document makes sense to the enforcement court in case that it's needed. And now just a few numbers about our, infographics in 2024. We had 811 cases, arbitration cases. These are purely international. The AAA administered more than 530,000 domestic cases, but these are the international ones, and 102 mediations. It's interesting to learn that 47% of ICDR panel members reside outside of the US, so you don't feel, or the parties don't feel, that we are mainly US arbitrators. We have people all over the world. Actually, our panel is comprised of around 700 arbitrators located in different countries and with different legal backgrounds. And just to show you a map of where are our main, the countries that are better represented in our cases. Obviously, our major participants are from the US, but we have also cases in other places. Canada has been the second place for several years, and China has also been an important caseload for us. And now let's talk a little bit about AI and data projects at the ICDR and AAA. As I said, we've been trying hard since a couple of years ago, and after our new CEO, Bridget McCormack, took office, she has been implementing AI in several parts of our institution. Internally, we've been working as employees of the AAA ICDR in adopting several AI tools that has been trained and closed enough to keep confidentiality of what we do. But we have trainings almost every week about what are the best practices and how to better use and take advantage of all these tools for all our activities. And as part of that, I prepare a list of what are the main AI-driven tools that we have created recently. We have a clause builder, AI assisted. So if you go to the website, you can actually interact with this AI tool. It will give you several options, and depending on how you train it, it will give you a better adjustment of the regular model clause to better draft a clause, an arbitration clause. This we don't pretend, obviously, that this will replace any legal advice, but at least you can have a good idea of nuances and things that you may include depending on what the tool gives you. We recently launched also an AI-assisted arbitrator. This is for now, it is limited to construction cases of less value. And the purpose of this is to have cases that will be decided by documents only by an AI arbitrator that will be monitored and reviewed by a human arbitrator. So what we pretend with this tool is to give access to arbitration to cases that maybe normally won't have access to it. And as our CEO has said several times, the main purpose of adopting all these AI tools is to actually extend the access to justice to other users and other business that may be not the usual eligible cases for regular arbitration. So this tool is actually part of that effort. So cases that are not probably that significant, but they still need someone to help them with resolving a dispute. We also had some months ago a group of arbitrators that agreed to use it, an AI-generated scheduling order. We asked the parties if they would be comfortable with trying this tool, and it was pretty interesting how, if an arbitrator has the first case management conference with the parties, after that, the arbitrator needs to create a scheduling order and, all the calendar for the parties to submit their pleadings. That exercise most likely will take the arbitrator like 2 or 3 hours at least if they are very experienced arbitrators. They probably have even templates that they may use and things like that. But we realized that if we could record that case management conference or procedural conference according to ICDR rules, the system would actually create a draft of the procedural order in just 3 minutes. So it's pretty amazing how the arbitrator will save all this time in creating a draft, and then obviously it needs to be reviewed, but the exercise of reviewing is definitely gonna implicate less time to the arbitrator than the fact of creating from the scratch. We prefer obviously that the arbitrators create all these documents according or tailored to the specific cases, so this will help them in this exercise. Another tool we have implemented is about the AI arbitrator search tool. So as I mentioned before, we work with lists of arbitrators. And what we had in the past was just a regular, search tool that was basically managed with keywords. But the problem with that was that if the arbitrator created a resume that did not include those specific keywords, it was hard for the case administrator to find the right arbitrator, or it will take the case administrator more time to actually find the right person, right? We had to review different parts of the resumes, make a double search, check on the text. So that exercise would obviously take us time. With AI tool, what we do is that instead of having just one point of connection with a keyword, we have like 9 points of connection in phrases and ideas instead of just the exact keyword. So there's more connections on the text that we are searching in the resumes than what we had before. It also creates even a comparison table between different expertise, different hourly rates. So it's pretty good how we can now see the information easily and we can compare and then choose the best candidates for the different cases. Another tool is the web file e-center. So now the arbitrators have and the parties have access to this AI assistant for document summarization and QA of documents. So we've had the web file for a long time, and it's actually a pretty useful tool because the parties have control of everything that is happening in the case in just one place, and they can upload documents, search them, keep a schedule of what's going on in the case and several things. So the web file itself, it's very useful and very friendly, user friendly. But with this AI tool, now the parties can also summarize documents, make a better search of what they're looking for, because when you've been in a proceeding for several months, you will have several documents there, and it becomes harder and harder to find them. So this is a tool that we have created for them to help them. Another thing we have is the chat box. We have created those to help the staff, panelists, and parties to have access to different information in the cases. We have one about the rules. So if you go to the website and you try to find information about a specific topic in the rules, you can find that easily. We also have a chat book about case preparation and presentation. We understand that there might be people that hasn't had a case, an arbitration case or an arbitration case with us. So we actually created this tool so they can be more accessible. The information can be more easily found, and they can prepare their case better in case they are new to the system, or sometimes they might be, just not represented by lawyers or stuff like that, so that this can help you. The Rules and Clauses app, we actually have an app that you can download in your phones, and you can check on the rules. As I said, we have different sets of rules. They are different in different ways. So you can have that handy. And also the Clauses app that I just described before, where you can actually draft your clause and make, all these changes to adopt them in your contracts. There's also a new tool called the API for large caseload. So if there might be law firms that have big caseloads that they are, like frequent filers, they just put together several cases. This is more applicable probably for consumer cases where, just one law firm represents hundreds of parties and they file one case for that purpose. Well, we have created this application so it makes easier for everybody to manage those cases. And we have a proceeding that is more efficient for everyone. And finally, the case shield. This is a tool that we provide to the arbitrators in case they don't have enough cyber protection to their files. So we assist the arbitrators with this tool. Um, we we normally we probably have, we have arbitrators of different types, big law firms that have very well programs and very well protected, so they don't have this concern. But there are also arbitrators that are, sole practitioners that need to create all these tools to protect confidentiality and just generally speaking to be protected against cyber attacks, which nowadays are a huge concern. And on that topic, we also included in our rules in our last amendment in 2022, the obligation of the arbitrators to discuss cybersecurity with the parties. Because since then, we understand that all these technology issues are important and we need to address them and to be careful on what we're doing. So all these tools that I have described have been tested and applied for several months before we actually put them out in the market. So we are very, very thoughtful and very cautious on what we put together and what we make available to the parties before we actually put it out there. And just a few, images on how this looks like. It's available in our website. So if you go to the website, you can see this, play a little bit with it. I highly recommend that you make an exercise, even if you're not actually looking for a clause, just get into the system. Again, play a little bit with it. It's very interesting. And there might raise questions too. So feel free to reach out to us and just ask whatever question you have. Another tool we have put together for arbitrators only is the Clear Brief. So Clear Brief is it's a program that helps the arbitrators to summarize documents, draft some, decisions. It's a very, very useful tool. And they can also check on the citations or documents that are relevant in the pleadings of the parties. This is available for arbitrators that have ICDR AAA cases, but it's also offered to arbitrators for other cases at a reduced rate if they are interested in using it for cases with different institutions or their own cases. So it's a very, very interesting, again, tool. It saves lots of time because you don't have to go through every document and search in every document what you're looking for. You can just enter the documents and make a very, very easy search for the key points that you're looking for. And obviously, all of this that I talk about are, at the end of the day, tools that we are trying, again, to use to enhance the process. So there has been, and I understand as lawyers, we are always cautious about technology. And I think that it's more like a tradition in our profession. We are not very familiar or very used to all these technology disruptions. But as long as we keep in mind that these are just tools, I think we can play safe. And it always ends up in the question of ethics, right? And I'm sorry if I put this in a very simple way, but I truly believe that as long as we understand that these are just tools that we are going to use to enhance our work as arbitrators and parties, we will be fine. And that is why we also created some standards on why we have to consider. I just listed them here. They are again available in our website. But the good thing about our standards that I think makes them different from other institutional standards is that we have the three views: the institution view, the arbitrator's view, and the party's view in each of them. So you will go there and understand why are we comfortable with putting together all these tools, and just understand that again, this is just a way to make better our performance and our roles in the arbitration proceeding. And I was just thinking that, when we started using computers, we started to write in computers, right? And back in the day, and I don't know if that's the case in all the world, but in Mexico, for example, lawyers used to have secretaries that actually, which they dictate what they wanted to put in their briefs. And the secretary used to write in a typewriter what the submission would look like. When we started using computers, we would never think that computers will think for us, right? It was just a tool, and it was just us typing in the computer and telling the computer what to put in the brief. I think this is obviously with the different proportion, but it's it's a similar thing. We are just using all of this to assist us in creating or recreating ideas that we already have. And these systems are as good as we fit them, as good as we train them, and as good as we use them for the right purposes. So with this, I finish my presentation and I'm open to any questions you may have.
Okay, thank you, Janet, for such an enriching session. So now I would like to invite the questions. I'll ask all the participants to come up with their questions, whatever they may have. And before we start the questionnaire session, I would like all participants to wait till the end of this session. Okay, so we have a very important announcement to make. So we can start with questions sessions right now. Yeah, please. If anyone of you have any questions, you're most welcome to ask the specialist.
Hello, ma'am. Am I audible? Hello, ma'am.
Yeah.
Am I audible? Yeah.
Yes.
So I want to ask, as a final year law student from India, aspiring to build a career in international arbitration, especially in this new era of AI and digital tools like chatbots and data-driven case management. So I want to know that what kind of skills or experience does ICTR value most in interns or young professionals?
Right. I think that the main thing is that you need to,
Hmm.
start to get involved in the practice, right? I used to hear a long time ago from one of my mentors say, like,
Hmm.
you can't pretend to graduate as a cardiologist and just feel that people will come to you asking for advice. You need to get around with other cardiologists, to be with people that actually need cardiologists for some reason, and then start to get known in that field. So I think it's the same here. And for the good news is that you have lots of opportunities in different institutions to start getting involved. For example, we have the Young and International group. It's a very, very dynamic group where we put together people from different uh, places of the world, different jurisdictions, and we have actually a governing body in that group. So you can postulate to be part of that governing body, and just getting involved with all the sessions and all the meetings they have. It's good to be known as an specialist and get involved with the practice of arbitration, but also to get to know people from other jurisdictions and just get like a global view of what's going on in terms of the practice of arbitration, but also the practice of law, which I think it's more important than anything. Another thing I would recommend is that you actually put some attention on getting expert in a specific field. Nowadays, it's important to know arbitration, but it's more important to know about the different sectors. if you focus on a sector and you get to know how that sector works, how those contracts live, all of that, it's very, very useful for the institutions, but also for the practitioners and also for the parties and the people in the business that you will represent. So I think those are my 2 cents. You get well known and involved with the people in the arbitration practice, but also get to know and get as expert as you can in a specific sector or practice of law.
I truly appreciate your valuable guidance on this. Thank you.
Sure, anytime.
Okay, there is a question from Chandra Prakash Chandan, I'm sorry. How will it help in research without plagiarism? Yanet, can you throw some light on this, please? Chandra,
I
Chandra,
can you rephrase your question? I don't think
okay,
I get it very well.
Chandra, Chandra, are you there? Okay, so next question, we'll hold on for that for the time being.
Okay.
Uh,
Mhm.
any other questions?
So I see something about contracts here. If we have any templates for contracts, not for contracts like as the whole, but again, the arbitration clause, it's it's there with this AI tool. You can create your arbitration clause and just include that in your contract.
Okay. Okay, any other questions for Yanet?
I see one about
So
international lawyers in
yes.
Mexico. Yeah. So I think, I mean, it depends on the law firm. I'm not sure nowadays, and I'm sorry about it. I've been in the US for 10 years, so I'm not exactly familiar of what the economic relationship is between India and Mexico. Uh, but I would probably just search for the top law firms in Mexico and ask if there's a way for you to participate with them somehow. I would say that we are culturally, we're very open, we're very friendly. Mexicans love everybody, as you probably know, so we won't have any issues on that. But in terms of practice, I think you will have to double check on the need of a Mexican law firm of having an Indian lawyer or practitioner at their office or working with them.
Absolutely. In fact, let me share with you, Yanet, one thing. Our law
Mhm.
students, they are more than interested in learning French and Spanish language. So as they can, we are also into it, that we are helping them learn Spanish and French language so that they can actually, go worldwide or any part of the world where they can practice on the international platform. So it's one
That
of,
would be great.
yes,
And
yes.
and you know what? We recently signed a cooperation agreement with a law school in Mexico. So, I mean, if there's any interest on us to connect you with them and see if there are any opportunities as a students or maybe after that, we are very open to that.
Absolutely, absolutely. See, languages. So, Asif is asking, in our studies, we often discuss the importance of human element in resolving disputes. As AI becomes more involved, how does the ICDR ensure that the essential human qualities of empathy and nuanced judgment are not lost in the process?
Again, we are very thoughtful about what we are trying to improve here, and that is actually the decision-making process of an arbitrator. I don't think we are still in the place where we will trust 100% to a machine to make a decision. Maybe we will. We don't know. We can have this conversation again in 10 years and see where we are by then. But at this point, I believe that what we are trying to do here is to provide the decision makers with tools that will remove all these, minor tasks that take so long for them to make, a brief or to create some sort of document and have that person actually focusing on making the decision. So that's the main purpose of all of this, having the decision makers focusing on decision making process. How it's going to help them, I think it depends on how this person trains the tools to do it. I was in Canada last week, and a judge from the bench that it's still serving as judge in the US told me that he actually has some sort of tool where he puts together all his decisions, and whenever he needs to make a decision according to his own judgment, he makes a search of that. This tool helps him to make a search of decisions made by him in the same issue, so he can actually refresh his own memory and take some of the ideas of decisions prior that he made in the past and perhaps adopt them and review them for this new decision. So that it's based for me, it was like, and he has been using it for several years. So for me it was like, exactly, that's exactly what we want, right? That we don't have to start everything from the scratch. We have a tool that will help us with all this work and then actually focus on what we need to decide. And again, in terms of having cases that will probably not be accessible for arbitration, we can actually extend our work to those smaller cases and at the same time extend our capacity of resolving disputes.
Thank you. Thank you so much, Janet. And it is, the session has been so insightful. In fact, students are asking for a session on procedure of international arbitration especially from you. So the whole
Right.
has been
I
so.
can I can spend I can spend an hour or more explaining you how the process works, and it's pretty amazing. We
Absolutely.
obviously different institutions have different processes, but yeah, we have a cycle of living in our process and all the stages and how it works. I would love to do that, certainly.
Okay. Okay. And what another question comes from one of our students. What do you think ODR has the scope in? Like, since online dispute resolutions are
Actually, Actually, the ICDR acquired ODR a few years ago. They have been working on providing online mediation services through us. It's to be honest and fair, and as you can see in the numbers that I provided before, we are obviously more identified as an arbitration institution. And that's probably because arbitration is in the name of the American Arbitration Association. Nobody thought about including mediation, which is, I think, a bad thing. But anyways, we haven't been seen as an arbitration institution more than mediation, but we're trying to change that. And we are implementing with the acquirement ODR and other initiatives internally to enhance our mediation process. To be honest, for me, personally speaking, I would say that mediation is the best way to solve disputes, even more than arbitration, because if you want the parties in control of the outcome of the process, mediation is the only one where they really can decide what's going to happen. How long it takes, it depends. And as long as we get the parties together and have this conversation, I think that will be the best way to do it. But disputes are not always like that. So arbitration is important, and we need to keep that in mind and give options to the parties. So ODR, I think it's a very good option. It's an online tool that has been very used and very productive for certain disputes. And as lawyers, that's exactly what we need to consider, I think. What is the best ADR for each dispute?
Okay. Thank you. Thank you, Annette. So any other questions we have for our specialist?
There's something about salary for arbitrators. That's an
Yeah.
interesting one, but it depends. I would say it depends. We have, as I said, an hourly rate, so we don't have any restrictions or anything like that for in terms of arbitrators' hourly rates. The arbitrator is free in our systems to set the hourly rate they think it's better and they deserve. So, but obviously we inform that to the parties when they make the selection from the arbitrators list. So we always tell the arbitrators, you have to be, you have to acknowledge that that may be something the parties will consider in their decision of who to select. So we ask the arbitrators to keep it fair, to keep it in the market. And, it depends on how many cases you have. You can be a
Tell her
very
not to
busy
ask.
arbitrator.
Tell her not to ask.
I'm sorry. Oh, yeah. So, we don't have internship applications, but there's a program that we have. It's called the Summer Student Summit. That happens in November, and actually the it is open for applications right now. I think the last day is September 29, so we are very close to it. But it's a program that we provide in our New York offices. The students are the ones that are selected, come to our offices, check on all our system, have the opportunity to meet with some arbitrators while we are there. And there's an economic contribution from the ICDR AAA Foundation to cover your travel costs. It doesn't cover 100%, but it's a part of it. So maybe if you cannot do it this year, take a look for next year. We do this every year, and we can check on the openings in the website.
So there's another very great, thank you, Annette, for that input. So another question we have from Komal is, how can law students leverage AI-powered tools to enhance their research and analysis skills in international arbitration?
Well, the best way you can do it is practice. You need to practice, you need to review, you need to get comfortable with it. I would look for programs at the university. I'm pretty sure universities are doing a very good job in putting together programs to train new lawyers because, that's the best tool the universities can give. But also search for outside training. You may have opportunities in different sections. For example, Clear Brief, you can probably take a look on their website, see if they have anything for free that you can probably access, play a little bit with it, and some other things. So I would just go ahead and get in the web and just find as many trainings as you have. Even with ChatGPT, you will be amazed of how many things you can get from it. As much as you train it, as much as you ask the right questions, which is sometimes the struggle with us because we don't know exactly how to get advantage of it. But there might be even free trainings on how to use that.
Okay, thank you, Unit, again. So we have with us Mukul also. He has joined the session, and we welcome Mukul on board. So we're glad to have you here. He's another specialist in ADR. He's from Canada. Mukul, the stage is all yours. The floor is all yours. If you want to contribute something for
Yeah,
my
I
students.
just want to thank I just want to thank everyone and specifically the unit and Mighty Brains. You guys did a really great job and I'm really happy for that. I think people are having a lot of idea about what exactly ICDR is doing and what what Mighty Brains thinks to do in future. I'm really glad. Thank you so much, Janet, and thank you so much, Mighty Brains, for giving me this opportunity and all stuff. Yeah, thank you so much. Yeah, that's all I
Pleasure is
want to
all
say.
ours. Pleasure is all ours. So,
Thank you. And I just want to take a minute to address the last question that I see in the
please.
chat. There's a question about how if Indian foreign student target to become an international arbitrator, and the answer would be definitely. I mean, but I would say that before becoming an arbitrator, the first step in a culture where arbitration is not as used as we would expect is just put arbitration agreements in your contracts. That's the first step, and that can be done as soon as you graduate from law school and get a contract in your hands. So try to do that as much as you can. In Mexico, you would be surprised, but we don't have like a really big arbitration practice. It's still a small group doing it and a small number of cases compared to what we have in courts. So there's still lots to do in terms of using arbitration and in terms of having more contracts with arbitration clauses.
Okay, we have one more question from Harnoor Singh Bindra. Harnoor, please go ahead with your question.
Good evening, ma'am. Good evening, sir.
Good
I
evening.
just wanted to request, ma'am, could you please repeat the summer school's name? Is it ICDR AAA Summer School?
Yeah, it's the Law Summit. It's AAA Student Law Summit, and I can send you. Give me just 1 second, very quickly. Let me see if I can find the link so you can take a look. Yeah, or I can probably check on, oh, here it is. So I'm gonna put the website in the chat, and if you have any questions, you can send an email to that address. And let me see, what else can I tell you about this? Oh, actually, the deadline is today. I'm sorry, but again, you can take a look for next year if you are not ready. And there's $1,300 to cover travel and lodging expenses in New York if you are selected. The rest of it you will have to cover it, but at least it's something.
So,
Thank you very much, ma'am.
Wonderful.
Thank you, sir.
Wonderful.
Mhm.
So we will still be looking for questions. You can mail us. We'll be sharing the mail ID with you all, guys. Please don't leave the session. We have a very important announcement to make, but before we move on to that, I would, from the core of my heart, thanks Dr. Yanet Caroz for all and from all the participants for being such a part of a rich and timely discussion. We hope this webinar inspires you to further explore the intersection of law, technology, and dispute resolution. Good luck on your continuing journey with AI and digital arbitration. And from the core of my heart, thank you, Yanet, from India and all the students. Thank you so much for such a wonderful session.
Sure. Thank you very much for having me. Thank you very much for your attention. And it will be my pleasure to collaborate again in the future. Have a very good day.
Same here. Pleasure is all ours, and definitely we'll collaborate in future. We are looking forward for it, Janet, and we'll discuss it. Thank you so much, Janet.
Perfect. I'm leaving now. Take care.
Thank you. You too. You too. Okay, guys, thank you so much. I want to thank everyone to make this webinar a great success. Before we leave, I would request few things. I'll say it in Hindi as well as in English so that everybody understands it very clearly. Anybody who has joined this session from the beginning would be entitled for a certificate signed by Yanet, right? किसी ने भी इस वेबिनार को शुरू से ज्वाइन किया है और अभी तक ज्वाइन किया रखा है तो they will get a certificate signed by Yanet in collaboration with the Mighty Brains. I would request everyone to submit their correct names, the correct spellings of their names and their profession in the chat box or in the WhatsApp group where you have already joined. I need everyone's correct name and their profession so that we can issue you these certificates without any mistakes. First. Secondly, we are very glad to introduce a certificate course. ये सब आपके लिए ही है. We are very glad to introduce a certificate course in collaboration with City Institute of Higher Learning Canada and Mighty Brains on ODR. Right? मैं दोबारा से रिपीट कर रहा हूं. हम लोग 4th October से we are launching a course on ODR. And the course would be taught by the faculty from CIHL, Center for City Institute of Higher Learning Canada. Mukul would be one of your faculty members, and the another would be Dr. Kubi. So anybody who is interested to explore the ODR course is most welcome to join that course. What will you get from out of that course is you'll get a chance to have international internship. Second, international certificate would be given to you from CIHL, City Institute of Higher Learning, right? A lot of quizzes, assignments, 400 pages plus material, articles, books, case studies, and a lot that will actually help you to work effectively in international arena. Okay, I want every student who has attended this webinar and anyone of the law fraternity to benefit from all these collaborations, and we personally are into it कि नहीं मुझे अपने हर स्टूडेंट के लिए बहुत एक ऐसा फील्ड खोलना है जहां पे वो इंटरनेशनल लेवल पे जाकर प्रैक्टिस कर सके, अपने को प्रोफेशनली ग्रो कर सके. So this is what we are offering, and anyone who is interested in this certificate course, please message me on the WhatsApp or the group you have joined in. So again, thank you so much all from the core of my heart. आपने इस webinar को you made a success, you made it a great success. And again, please be in touch. Don't go, and thank you so much. Two things, please remember your correct name and your profession, right? And secondly, we are introducing, we'll be telling you more on online on WhatsApp. Please check, please keep your WhatsApp updated, like be updated on your WhatsApp, sorry. So for that, for the course we are going to introduce on October 4th. The course is going to start on 4th October, and that is certificate course on online dispute resolution. That is in collaboration with City Institute of Higher Learning Canada and Mighty Brains. Thank you so much. And with this, I would end this session. I sincerely thank Pooja, Nikhil sir, Shivashish for their hard work, dedication, and teamwork. Guys, your efforts, commitment, and support have been invaluable in achieving this goal. It's truly inspiring to see how we come together, overcome challenges, and deliver with excellence. I deeply appreciate your contribution and look forward to continuing this journey of success with you. And thank you all, and have a great night. Thank you so much. Yes, of course, we'll be sending the information in WhatsApp group, Anand. Of course, we'll be sending the information. Any other question anyone wants to ask, please, you're most welcome to ask. So I guess we can end this session. Thank you all for your time. Bye. Bye.